Okay, good morning, audience. Thank you, everyone, for joining. In this webinar, as an audience member, you will stay on mute. We won't be able to have a one-on-one dialogue with you. However, at the end of each segment, we will provide time for questions. We will provide time for questions. However, at the end of each segment, we'll provide time for questions, and how you can do that is in your little rectangular screen. There is a little blue chat box. And in that chat box is where you can type your message or question. And please make sure you click the send question to staff. That way your question will be logged. And because we have over 200 attendees, in the interest of time, we won't be able to answer all your questions. Again, what we'll do is pause after the end of each segment, pick a few questions to answer, and any other questions we can't get to, we'll save towards the end of the webinar, and remaining questions we'll be happy to follow up through email. And I know during the registration, we also receive questions. We'll also receive questions if we will focus on commutations, which is another type of clemency granted by the governor that does not change or reverse, but rather allows the governor to reduce or eliminate the conviction. And majority of those that apply for commutations are incarcerated community members currently serving LWOP, life without parole, or determinate and lengthy sentences. We definitely want to clarify and emphasize that before we proceed with the webinar that yes, although commutation will be mentioned in AB 2845, however, our focus today will be sharing information with you on how to file a pardon application and who qualifies for pardons. And a pardon is for anyone who currently has a state conviction and also must meet certain criteria, which will be discussed in this webinar. Again, we can't emphasize enough that the purpose of this webinar is our way to help empower you to help others or for yourself on how to present a compelling pardon application. And we know that also there's folks in the audience who are from states such as Rhode Island and Massachusetts, and we recognize that each state has its own pardon process, but we will share general concepts that you can use that can apply for your state. And lastly, before we start, we're happy to share that there will be a second webinar, and it will focus on commutation, so that is coming. And also, there were questions that this webinar will be recorded. Yes, it'll be available for those who request it through email, and we'll be happy to share that webinar with you. Thank you so much. And I would like to start with the first segment. For the agenda, we'll start with a brief overview, and as you see, it's divided in 6 segments. After the end of each segment, that is when we'll make sure to have time for Q&A before we move to the next segment and so forth. And again, for the questions, go to your chat box, and if you can, address the questions to staff. And the first segment, I'll be introducing the presenters. Second will be overview of the pardon process in California. Third, post-conviction relief. Fourth, how to present a compelling pardon application. Fifth, personal story of Paul Sox sharing his pardon process. And sixth, understanding AB 2845 Pardons and Commutation Reform Act. And we just want to give a shout out to the Immigration Legal Resource Center, State Bar of California approved MCA provider. We know that there are quite a number of attorneys in the audience right now, and we'll definitely, with the information they provided, we'll give you 1 hour credit for it. Okay. And now we'll move to the next, our presenters. So besides myself, hi again, I'm not sure if I introduced myself to you, but my name is Nourn from Asian Law Caucus. And my first presenter I'd like to present is Angela Chan. And Angela, she is the Policy Director and Senior Staff Attorney at Asian Law Caucus in the Criminal Justice Reform Program. Angela works focused on defending and building on California Values Act, SB 54. A landmark state sanctuary law that Angela co-wrote and passed in 2017 to further strengthen protections for immigrants against local and state law enforcement entanglement with ICE. Angela has co-authored and collaborated with the ICE out of California statewide coalition to pass the Trust Act to limit response to ICE hold requests and the Truth Act to require local law enforcement to provide consent forms prior to interviews with ICE. Currently, Angela will be implementing AB 1282, the No Private ICE Act, a bill which will limit state prisons from turning individuals over to private security corporations that have been contracted by Immigration and Customs Enforcement, or also known as ICE, to conduct immigration arrests and to transport individuals to immigration detention. And that is Angela Chan. And our next panelists, we have the esteemed Anoop Prasad, Senior Staff Attorney at the Immigrants' Rights Program at Asian Law Caucus. He focused on representation of low-income API immigrants in deportation proceedings. In particular, his work focuses on the intersection of the immigration and mass incarceration in the criminal system. To current era, a particular focus for Anoop is one, protecting the due process rights for unrepresented immigrant detainees with serious mental health issues, and second, his work to stop deportations of Southeast Asian refugees, namely Cambodians who are currently being targeted and deported. With that, Anoop has been relentless in helping clients submit pardon applications as a way to stop their imminent deportations. And for myself, hello, my name is Mia Nourn. I am the 2018 Yuri Kochiyama Fellow with Asian Law Caucus. The fellowship was created for formerly incarcerated community members to lead advocacy work to end deportations and provide support for incarcerated community members in prisons and detentions. Also, I work closely with Angela and Anoop in the Criminal Justice Reform and Immigration Rights Program because both programs intersect and their overlaps focus on challenging and dismantling our criminal and immigration carceral systems. Since my fellowship started, I've been honored and fortunate to work on passing AB 2845 into law and help with advocacy work to obtain pardons for a few Southeast Asian community members through the Pardon Refugees campaign launched in September of 2018. And our third panelist, I would like to present Rose Cahn. Rose, she is the criminal and immigrant justice attorney at. She is the criminal justice attorney at the Immigrant Legal Resource Center. Rose is nationally recognized expert in the field of immigrant and post-conviction relief and oversees the ILRC's Pro-Bono Immigrant Post-Conviction Relief Project. Rose has over 15 years of experience working in the field of immigrant rights and a special focus on the intersection of criminal and immigration law. Rose also spearheads federal, state, and local advocacy to help advance the rights of immigrants with criminal convictions and provides an understanding how to better serve this population. Rose Cahn. And last, Phal. He currently works as a community organizer with Youth Justice Coalition in Los Angeles. Paul's work focused as a support system for youth, family, and formerly and currently incarcerated people's movement to challenge America's addiction to incarceration and race, gender, and class discrimination in Los Angeles County, California, and the nation's juvenile and criminal justice system. Phal, he's a powerful and compelling advocate, formerly incarcerated community member, and leader. And we're so happy to share that last year, in August 2018, Phal was granted a pardon by then Governor Jerry Brown. So those are our esteemed panelists, and we're so grateful to have them present along with me. And we'll move forward to our second segment, which is the pardon process in California. And for this segment, we'll focus on what will be covered in terms of the segment. It's why seek a pardon, who can apply for a pardon, how many pardons have been granted in the history of California, what are steps of the pardon process for a direct gubernatorial pardon versus a pardon application supported by a certificate of rehabilitation or COR, and what happens if a pardon do not apply to you or someone you're helping? Is there post-conviction relief available? Now I would like to hand it over to Anoop to present on why should a person seek a pardon.
Thank you, Nia. I'm going to talk about why someone should seek a pardon. Pardons can have some extremely helpful benefits for people with convictions. However, there may be ways to get the same outcomes without a pardon that are easier and quicker. Later on in the presentation, Rose will talk about some of those alternatives. One of the most dramatic effects of pardons that we've seen has been for immigrants with deportation orders due to a criminal conviction. The impact of a pardon for former green card holders who lost their status due to a conviction can be dramatic. They can go from being days away from deportation and never being able to return to the United States to suddenly having their status restored and being eligible to apply for U.S. citizenship. People with prison sentences are barred from many post-conviction vehicles, leaving pardons as one of their few options. Pardons, however, may not be helpful for all non-citizens seeking relief from deportation. Pardons may not be as helpful for undocumented people or people facing deportation for a drug, firearm, or domestic violence conviction. A California pardon is also not available for a federal conviction or a conviction that's out of state. The Immigration Act does not recognize pardons for certain grounds of deportation as well. Before applying for a pardon, it's helpful to consult with an immigration attorney to determine if a pardon would help and if an easier option may be available. I'll turn it back over to Nia to talk about the history of pardons in California.
Thank you, Anoop. For this slide, how many pardons have been granted? Since the tough on crime policies of the 1990s that led to sharp increases in disproportionate confinement of minorities and a mass incarceration crisis, California governors have granted very few pardons or commutations. Last elected Governor Brown, he granted 1,736 pardons in his third and fourth terms. By contrast, from 1991 to 2010, 3 California governors granted a total of just 28 pardons. Under the current process, there is little transparency around the pardon and commutations process. Individuals who apply for pardons and commutations, especially those doing pro se without legal help, do not know if the request was received, if it's being reviewed, and if when a decision will be made. However, with AB 2845, the Pardon and Commutation Reform Act, there will be a bit more transparency, yet pardons and commutation reform is still needed. With that, we will continue to urge Governor Newsom to build on these reforms and continue for him to follow in Brown's footsteps with pardons and commutation grants. And now I would like to pass it over to Anoop.
Thank you, Nia. The pardon process in California is rather antiquated. We'll talk about recent legislative efforts to modernize the process and provide transparency later in the webinar. Generally, though, the governor has wide discretion to grant clemency, including pardons, to people with convictions in California. There is one key restriction that we'll discuss in a moment placed by the California Constitution. Generally, there are 2 avenues to apply for a pardon: a certificate of rehabilitation and a direct pardon. We'll talk about each of those. Most people granted pardons have gone through the certificate of rehabilitation process. To qualify for a certificate of rehabilitation, you must have a felony conviction or a conviction requiring sex offender registration. There are also other restrictions on certificates of rehabilitation for people sentenced to death in state prison, people on mandatory life parole, and people serving in the military. You must also be off parole, have a varying period of rehabilitation, and have lived continuously in California for 5 years. People residing outside the state are ineligible for a certificate of rehabilitation. Due to AB 2845, immigration status is not a bar to eligibility for a certificate of rehabilitation. Generally, to apply for a certificate of rehabilitation, you apply in Superior Court in your county of residence or the county of conviction. The court in that county should have an application available for you to apply, and the public defender's office should provide assistance in applying for a certificate of rehabilitation. It is possible during the process that the DA's office or probation office will conduct an investigation and possibly oppose your application. If a certificate of rehabilitation is granted by a Superior Court judge, the application should be forwarded to the governor's office and treated as an application for a pardon. However, this does not happen consistently. There are 2 scenarios in which you should seek a direct pardon rather than a certificate of rehabilitation. One is if you do not qualify for a certificate of rehabilitation, and the second is if you do not have time to go through the certificate of rehabilitation process because you're facing imminent deportation. I also mentioned one large restriction on the power of the governor to grant pardons in California. The California Constitution requires that before the governor can pardon or grant clemency to someone twice convicted of a felony, at least 4 justices on the California Supreme Court must recommend a grant. There's no process to apply directly to the Supreme Court for a recommendation. Rather, the governor's office chooses to send some 2 felony applications to the Board of Parole Hearings for an investigation. If the Board of Parole Hearings provides a recommendation, then those cases are sometimes sent by the governor's office to the Supreme Court. There's no hearing before the Supreme Court, and there's very little guidance on the role of the Supreme Court in this process. Last year, the Supreme Court issued an order clarifying that they're not reviewing the merits of an application, but only serving as a check on abuse of power by the governor, particularly corruption. However, a few months after issuing that order, the Supreme Court inexplicably denied a series of applications for the first time in decades, where there was no signs that there was an abuse of power. It may be possible to bypass the Supreme Court even if you have multiple felony convictions. Multiple felony counts from the same case should count as one felony. It may also be possible to reduce felony wobblers to misdemeanors and avoid having to go through the Supreme Court. Rose will talk more about those vehicles later. I'll turn it over to Nia.
Thank you so much, Anoop. So why post-conviction relief is necessary to stop deportations? Currently, due to the sharp increase in immigration arrests under the Trump administration, one of the primary reasons people have been seeking pardons is to obtain potential relief from deportation. Although individuals with convictions may spend years turning their lives around to become productive and law-abiding residents, immigrants are faced with the risk of being sent back to countries where they have little or no ties to. And this is a campaign to pardon refugees, adding to what I shared earlier in terms of immigrants seeking pardons. Again, Asian Law Caucus started a pardon refugees campaign launched September 2018 with support from various organizations, faith leaders, pro bono attorneys, and community members. We have targeted Brown to pardon Southeast Asian refugees as a way to stop deportations. By Christmas Eve, 5 were granted pardons, 5 community members, and none of the pardons would have been possible without community support. And the photo you see is an action last year in October inside the state capitol in front of the Bear. And we delivered a petition to the governor with over 35,000 signatures from the community urging for pardons. And now we will have time for Q&A. And if you can, type your question in the chat box and I will see. Okay, I have one question that says, can pardons be expedited or is it at the governor's will? And would you like to answer that question?
Sure. AB 2845 for the first time provided some guidance on timelines for pardons and expediting pardons. If you are applying for a direct pardon of the governor and are facing imminent deportation, it's important to notify the governor's office about that. Angela and Nia later on the webinar will be talking about some of the time limits on pardons that were placed in by 2845 and also a process for expediting it.
Can I have some frequent question that's asking, can you please specify what's the difference between pardon and commutation?
So generally, we use the term clemency to refer to both pardons and commutations as a discretionary act by the governor to grant someone relief. Clemency generally reduces someone's sentence. It can reduce it from death to life. It can reduce a sentence that's life without the possibility of parole to life with the possibility of parole. It can reduce a sentence down to just a straight time. A pardon, rather than changing the sentence, forgives or erases the fact of the conviction itself. Both of these could be helpful for immigration consequences in different scenarios, but generally it's pardons that people have applied for to relieve the consequences of deportation.
Then I have a question. Can a person who is incarcerated for a felony apply for a pardon?
Absolutely. So most people who are applying for pardons are applying because they have felony convictions. The governor has really wide authority to pardon people with felonies, even for serious felonies, and as we'll hear later, even people with life sentences have been granted pardons in recent history in California.
Thank you, Anoop. And we'll take one more question. So if someone is deported from California, can they still apply for pardon even if they're in another country?
Absolutely. They're not going to be eligible for the certificate of rehabilitation. As I mentioned, you have to be residing in California, but they can still apply for the direct pardon. And Governor Brown granted a number of pardons to deported U.S. military veterans in Mexico. And they were granted pardons and were able to return to the United States as permanent residents.
And actually, we'll have time for one more. I have a question. Drug and gun charges, is that okay too?
So generally, the Immigration Act does not recognize pardons as being effective for gun and drug charges. Some good news is that almost all firearm charges in California should no longer be aggravated felonies or deportable offenses. Drug convictions are a little bit trickier, and it might be worth looking at other vehicles that Rose will talk about in a moment for drug charges rather than a pardon.
Thank you so much, Anoop. There's definitely lots of questions with over 100 folks in the audience. We'll definitely save some more questions towards the end, and any unanswered questions will follow up with an email. So now we'll continue with segment 3, and I would like to pass it to Rose to present the California Post-Conviction Relief Vehicle. Thank you, Rose.
Hello, everyone, and thank you to the Asian Law Caucus for organizing this. I am going to zoom out a little bit and talk about the other tools in the toolbox of post-conviction relief vehicles. Pardons are an absolutely essential component, but there are many other tools as well, and as Anoop has alluded to, depending on the facts of your case and the specific immigration consequence that you are facing, some of these other tools may be necessary to utilize either on their own or in conjunction with a pardon. As Anoop noted, pardons are, under the INA, pardons are found to eliminate certain aggravated felony grounds of mandatory deportation, and the crime involving moral turpitude ground of deportability. But there are many other grounds of deportability, like controlled substances offenses, domestic violence offenses, and firearms offenses that may not be eliminated by a pardon. In addition, for undocumented people who are concerned with the grounds of inadmissibility, or to put another way, bars to getting some form of immigration status, the pardon process may not remove the crime bar to getting some form of legal status. In those cases, we need to look at the array of other vehicles that exist. And we are fortunate that California has been a national leader in adopting new and varied ways of allowing people to go back into criminal court and modify a sentence or a conviction in a way that immigration authorities are required to respect. So we have been incredibly active in the California state legislature over the last few years in developing new laws that provide new avenues for people to mitigate or eliminate the long-standing consequences, immigration or otherwise, that can attach to even low-level convictions. The slide that was just shown is available for download on our website, and we'll make sure to send out the link to everyone. There are some cases where if you are facing a sentence-based immigration consequence, that is, you are facing grounds of deportability because you have a sentence of 365 days or more, you can turn to different vehicles like Prop 47 or Penal Code 17B and change that felony to a misdemeanor. And once that felony is now a misdemeanor, it is able to take advantage of the new misdemeanor maximum sentence of 364 days, which means that that sentence of a year or more, which made you deportable, is then eliminated from your record. So that can be a crucial and sometimes mandatory, in this case of Prop 47, way of eliminating immediately the immigration consequences. In addition, these felony to misdemeanor reductions, or even in some cases like Prop 64 felony to infraction reductions, can be used if you are facing the 2 felony hurdle to getting a pardon. So if you've got multiple convictions on your record and 2 felonies, well, you might be able to use the Prop 47 or Penal Code 17B to take that felony turn it into a misdemeanor, and then you only have the one felony, so you can avoid that 2 felony hurdle to getting a direct pardon. In addition, there are other vehicles or opportunities that allow you, after your conviction has been served, or for some individuals when they're currently incarcerated, to go back into criminal court and erase the conviction. This slide lists some of those most commonly used vehicles. They include Penal Code Section 1473.7, which allows people who are no longer in criminal custody to erase the conviction if they can allege that they failed to meaningfully understand the immigration consequences. Again, this is filed in the criminal court rather than with the governor, and it's a legal claim that you didn't meaningfully understand or that you had a claim of actual innocence. In addition, there is a vacator that is mandatory that applies for people who had deferred entry of judgment convictions on drug offenses. Again, this is mandatory, and if you're facing the controlled substance ground of removability, this vehicle, which can be filed pro se with a very simple form, can immediately eliminate that ground of removability. In addition, some new vehicles have gone into effect, like the SB 1437, which reformed the prior felony murder rule. People who were convicted under that old rule are now eligible to have that conviction modified to reflect what the underlying conduct actually was. So it can take what could have been a felony murder conviction and turn it to a straight, for example, assault conviction under 242, which is not a removable offense. So some of these pieces of legislation were drafted specifically to help mitigate immigration consequences, and some were drafted with the wise intelligence of the criminal justice reform community, seeking to mitigate the undue harm caused by this discriminatory system. But bringing the two intelligences together, we can figure out how to create new pathways for many individuals to remain here. Now, I know I've gone through a lot and it's technical. Feel free to turn to us at the ILRC if you have any questions. Many nonprofits that do removal defense or public defender offices are also well-versed in these different vehicles, and in some cases can help represent individuals in filing for these. So it's just important to recognize all the different tools that exist in our toolbox of post-conviction relief. Before passing it to Anoop, I have time to answer any questions that people may have.
Thank you so much, Rose. I'm sorry, there's been some, in order to ask your question, go to your chat box, and then there's a drop box, type in your question, and it says send to staff. We'll look at the questions for now. Let's see, okay. I have a question. Okay. Okay, I don't see any questions. Okay, so we'll go ahead. Thank you so much, Rose, and proceed to the next segment. In our first segment, how to present a compelling pardon application, and in this segment, we'll focus on how to fill out a direct pardon application, how to answer the 5 main questions of the application itself, such as circumstances of the crimes and why applicant is seeking a pardon, and should an applicant be granted a pardon. And I will pass it over to Anoop.
Thanks, Nia. I'm going to be going over some pointers in filling out the direct pardon application. The application form that I'm reviewing here was used under Governor Brown. Forms are still being finalized by Governor Newsom's office, but will likely ask similar questions. People who are granted certificates of rehabilitation may also end up needing to fill out additional forms from the governor's office. A lot of the information and discussion that I'm providing here is also available in a pardon guide that we released that's available online at bit.ly/pardon guide, capital P, capital G. The pardon application will ask for your conviction summary. It's important to disclose all convictions, not just the one that you're applying for a pardon for, including misdemeanors and also cases that were prior to your conviction that you're applying for a pardon. The governor's office and the Board of Parole hearings will be conducting their own background check and investigation. It's helpful to disclose all convictions and negative information up front so you can provide context rather than having them find out about it through your rap sheet. If you're uncertain of your conviction history and the details of the dates and sentences, you can obtain court records through each county or also request a background check through the FBI or through the California Department of Justice LifeScan process. For California Department of Justice LifeScans, you can look on their website and get a list of locations where you can request a background check. The application will require you to provide some information on the conviction for which you're requesting a pardon. Talking about the conviction can be tricky and challenging and requires some strategic thought. We're going to be going over 3 scenarios. One situation where you accept full responsibility for what happened. A second scenario where you accept some responsibility for what happened, but the actual conviction doesn't reflect your culpability or role. And finally, applying for a pardon where you actually claim innocence and were not guilty of the offense. Generally, a pardon is an act of forgiveness. Claiming to not have had any responsibility is not necessary and may not always be helpful. So the first scenario, the first scenario we're going to be discussing is where you take full responsibility for the crime. It's important to acknowledge personal responsibility and your own culpability. Describe how you caused harm and demonstrate remorse for your choices and actions. At the same time, you can also explain the factors that led to you committing the crime without minimizing the harm that you caused. You can share factors that were in your childhood or upbringing that led to you committing the crime. If you're a survivor of domestic violence or past trauma as a refugee, you can provide information on how this shaped your outlook and your role in life. We'll also be sharing some examples of responses that take full responsibility. The second scenario might be one in which you take partial responsibility, but for example, may not be the person who caused direct harm. This could be a situation in which you were convicted as an accessory or a conspiracy, but were not actually directly responsible for the harm. There's a tricky balance here between showing that you accept responsibility, have insight into the crime, and are expressing remorse, while also not taking responsibility for more than your actual conduct. You can walk this by taking responsibility for having placed yourself in a situation which resulted in someone being harmed without actually accepting responsibility for causing the direct harm to the person. This can be tricky, but it is possible to walk this line between the 2 scenarios. Finally, the trickiest situation may be one in which you maintain innocence completely for the crime. How you talk about this conviction, where you played actually no role at all in the conviction, is difficult. It may also depend on whether or not you accepted a plea deal, in which case you'll want to provide some context as to why you accepted a plea deal rather than going to trial, which may have been a strategic decision depending on how much time you're looking at. Or if you were convicted at trial, explaining why the evidence at trial didn't accurately explain what happened. It can be very difficult to convince the governor to grant parole or clemency where you're actually maintaining innocence, but it is possible.
Thank you so much, Anoop. If there's a slight pause, it's because Anoop and I are in the same room. We're muting and unmuting each other because there's an echo. Okay. So I'm going to give you an example with the circumstances of the client, and this is the facts surrounding an actual LC's client, and he gave us permission to share the facts surrounding his client. And in the first paragraph, he described his actions, the roles he played, this decision he chose that led up to the murder of his victim and additional crime of robbery. He showed accountability for both crimes and definitely not justifying his behavior to reduce his culpability, which can look bad as minimizing his behavior. In the second paragraph, he states reasons, his beliefs at that time why he started getting involved in gangs in the first place. And that is showing insight into his behavior, his self-reflection, being able to not only accept responsibility, but the ability to express the truth of what he was thinking and feeling as a 12-year-old joining a gang and as a 14-year-old who committed robberies. So for the interest of time, I'm not going to read the actual example, but I'll probably give you a chance to read it for yourself, okay? And I'll move it to the next slide, which is why applicant is seeking a pardon. So under the new law of AB 2845, BPH is supposed to consider expediting a pardon application involving urgent issues such as deportation. Applicants should note that this clearly embolded if they would like their application expedited. Since we're seeking direct pardons, explain why you do not qualify for a COR or Certificate of Rehabilitation, or the urgent need to bypass the COR process because of a pending deportation. You can attach news articles, show people are being rounded up for deportation to the country they're trying to deport you. You can share your family history, including if you came to the United States as a refugee or fleeing violence or persecution. Any ties to the U.S., length of residence, and family ties, and emotional and financial hardship that deportation would cause to you and your family. And also country conditions if you fear discrimination or persecution should you be deported. And now Anoop will share why applicants should be granted a pardon.
Thanks, Nia. This process is very daunting, but it is worth noting that you can navigate this process even if you don't have access to an attorney. A number of successful pardon applicants over the last couple of years have been able to get pardons granted without an attorney. A core part of your pardon application will be your statement describing why you should be granted a pardon. The statement will include a discussion of the actual crime, of your process of change and rehabilitation. If you took part in programs either in the community or while you're incarcerated that helped, insights that you've developed into factors that led to your incarceration, and how those behaviors and skills have changed. You could also highlight positive activities that you've taken part in, include things like community service, work history, family ties. If you volunteer in the community, highlighting those factors. For some pardon applicants, those have been critical in their grants for a pardon.
Thank you, Anoop. And I have one more slide before we have Q&A. So if you do have questions now, please feel free to log them in. An example, why should you be granted a pardon? And this is the same example from the 14-year-old client who was involved in a crime of robbery that led to his victim's death. And I'm going to read an example in his statement. He said, I live with the awareness that I owe the victim's family and the victims of my 2 robberies a debt that I can never repay. And I will carry that debt and regret with me for the rest of my life. Although I can never repay the debt, I have spent every day of my life since I came to the realization dedicating to serving victims of trauma and learning how to engage with others who have committed harm to end the cycle of violence. This motivation led me to become a certified alcohol and substance abuse counselor, a rape crisis counselor, a domestic violence counselor, and certified group facilitator for a bad risk program. I live every day with the knowledge that I have caused terrible harm and a powerful drive to make amends for that harm. I believe that those who have committed violence must be part of the solution to ending violence, and that I can utilize my experience, mistakes, and training to build a safer and healthier California. And again, it's his stating reasons why he should be granted a pardon and giving a second chance and expressing who he is today and recognizing he can never repay back his victims to society, but understands the value of making a lifetime commitment to continue making amends to his victims, society for his crimes, that is living a life of service to his victims and community. Now I'll pass it to Anoop.
As I mentioned before, the core part of your pardon application is going to be a personal declaration. The governor's office will likely have little to no information about who you are other than what you submit in your rap sheet. So it's important to provide context because the rap sheet doesn't adequately paint a full picture of who anyone is. It's important, especially if you're coming from a refugee or asylee community, to provide a history lesson in there about the impact that war, trauma, and genocide had on you personally and on your family. You can use that to not provide excuses, but provide explanations about why you came in contact with the criminal justice system. You should talk openly and directly about any of your convictions, including the conviction which you're applying for a pardon and any other convictions that you have. Provide insight, accept responsibility if that is the avenue that you're going down, and provide context for the conviction. It's also important to provide information on rehabilitation, changed circumstances, family, if you don't have immediate family, the role that you might play in your extended family, the role if you help take care of your parents or elderly relatives, if you're a core part of the life of a niece or a nephew or a cousin, providing information about that. Providing information on work history, community engagement, volunteer work. If there are people in your family who have serious medical issues, providing information on that, including medical documentation. It's also important to provide information on the situation with ICE. If you're from a country that's actively accepting people for deportation, it's important to provide that information to the governor's office. If you have a deportation order, you should be upfront about that because it shows the dire situation that you're facing and why a pardon is needed. It's also important to provide information about the impact deportation would have on you personally and your family. If you're afraid of being persecuted or harmed, if you're deported, if you're from an ethnic minority community, it's important to provide some of that information. There are generally reports available online about how people from different communities are treated in different countries. So it's also important to provide that background to the governor's office. So I'm going over a list of things that you can attach to the application. The first is support letters. In the pardon guide that I mentioned before, there's some sample support letters. Support letters are really key. You should gather support letters from anyone in your family, circle of friends, or community who knows you well. Support letters should be personalized, explain how they know you, what role you play in their life, and why it's important to them that you get to remain in the United States. You can also provide documentation of family ties. You can provide birth certificates for children, declarations and statements from family members, providing evidence of work history, a recommendation letter from your employer. If you don't want to disclose your criminal history or immigration situation to your employer, you can ask them for just a general support letter or reference letter, or alternatively can submit tax returns or a tax transcript that you get from the IRS. You can provide information on community ties if you do any volunteer work or donate money, getting a letter from those organizations. If you've done any education, if you've gotten a GED, a high school diploma, if you're taking college classes, documentation of that. If your family would face financial hardship if you're deported, you can document that by creating a budget summary or attaching copies of bills and pay stubs. As I mentioned before, if you have family members who are facing medical hardship, providing documentation of that, Often medical records are rather difficult to decipher, so if you ask the doctor to write a short letter explaining, one, the medical hardships that your family member faces, and also if you play a key role in taking care of that family member, assisting them with medication or taking them to doctor's appointments or translating for them at doctor's appointments, having that also be included in the letter. You can provide information on country conditions, as I mentioned before, if you fear being persecuted in your home country, providing information on that, or if there's issues with high rates of poverty or other violence in your home country, providing documentation of that. There's a good amount of documentation, for example, on people who are deported to Cambodia and issues they face related to poverty, discrimination, depression, mental health issues that you can provide. Immigration documentation, if you have a removal order and are checking in with ICE, you can provide a copy of the removal order or your order of supervision check-in sheet, which shows the urgency of granting a pardon. Finally, you can also submit prison records if helpful. You can request a copy of your C-file through CDCR. There is a charge for getting a copy of your C-file, but any chronos that you obtained while you're in prison, other certificates, recommendations from CDCR staff should be in there and may also be helpful. I'm going to go over some do's and don'ts for submitting a pardon application. It can seem like a very daunting process, and often for people, it's something that if they're applying themselves, that they put off because it's such a huge undertaking. So some things that might be helpful is mapping out a timeline for obtaining supporting documentation. Do review all the letters and documents that are submitted to make sure that they have appropriate content. If the person says in the letter that you've never done anything wrong or you've never committed a crime, you may want to think about having them edit that letter. People are writing a support letter and they don't know about your criminal conviction. It's better to have them not talk about it at all rather than say that you've never caused any harm or done anything wrong. If you need help understanding cultural context for your family's background or immigration history, you can try talking to people about your family about what their experience was coming to the U.S. And their experience having to flee their home country. You should use humanizing language when referring to yourself. There's some helpful information in this guide that's linked here on the slide about how to talk about a criminal conviction or people's convictions in a way just more positive and humanizing. And then finally, unless you're claiming complete innocence on your conviction, don't try to minimize or hide your convictions. I know often that's people's instinct, but it often makes it seem like they're not taking responsibility and can create some additional hurdles in. Now we're going to open it up.
Thank you so much, Anoop. So 10 minutes ago, I said we're going to open for Q&A, but I forgot there were the 3 additional slides that Anoop had shared. Okay, if you can remember, go to your chat box and click the send questions to staff. And let me see what questions do we have right now. Oh, that's Paul. I have a question. Could you use experts to help describe the mental health effects of the trauma on Southeast Asian refugees, big picture, community-wide? I'm sorry, I'll read that again. The question is, could you use experts to help describe the mental health effects of trauma on Southeast Asian refugees, big picture, community-wide?
Yeah, that's an excellent question. So there are a couple of scientific journal articles out there conducting surveys in the Cambodian community and other Southeast Asian refugee communities on rates of depression and PTSD in those communities, which are helpful to submit. I think at this point we've done a pretty good job as a community of educating the governor's office about these experiences, but it's definitely helpful to submit those. There's also some articles out there about depression and other mental health issues among people in the deportee community in Cambodia as well that are worth submitting.
Thank you, Anoop. And then I have another question. It says, considering the governor's office may be reviewing many pardon applications, do you know how long it takes them to review each file? Additionally, is brevity preferred in the application statement, or is it more beneficial?
I don't think brevity is necessarily necessary. I think the pardon applications tend to be quite lengthy with a lot of background. So I think especially in the personal statement, you should provide a lot of context. The application form itself might have only a few lines, but I think providing a very detailed declaration, explaining your life story, the circumstances of your conviction, how you've turned your life around, and who you are today is really important. Timeline on direct pardon applications is very blurry. We'll talk about some of the timeline language in AB 2845, but it may take quite a while. A lot of people have applied for pardons over the years, and years go by and they just never hear anything. That should be changing a little bit with 2845, but there isn't a super strict timeline in place.
Okay, I have another question. Actually, question and comment. My only current conviction, what would be my best course of action to get rid of my lifelong obligation to register and restore my rights? He's a 290 registrants for 20 years.
Right. So I'm not an expert. I know there is a multi-tier 290 registration scheme that is rolling out in California. It's possible that a certificate of rehabilitation might be helpful in dealing with the 290 registration. I don't know if Rose or anyone else on the call has more insight on specifically on 290 registration. I know the process is changing in California.
I don't know about the new process. This is Rose, but I can say that vacating the conviction, including the registration, I've seen that successfully used in a number of different cases. Of course, whether you have the grounds to meet the standard for vacator is a very case-specific inquiry.
Thank you, Rose. We'll have time for 3 more questions. In writing the reasoning to be granted pardons, how do you separate yourself if you are an immigrant with family ties? Presumably, many people have family ties and families would struggle. How can an inmate show special hardship?
Ultimately, I wouldn't think about it as needing to show yourself as being more deserving than everyone else. It is really arbitrary and random as to who gets granted and which applications don't get granted. So I would just try and show the situation that your family is facing as best as you can. Obviously, deportation impacts every family where they lose a family member or a loved one. So I'd just try and provide as much context as you can about the impact it would have on your family in particular.
Thank you, Anoop. And we have time for one more. And this question is, do you have tips on how to approach pardon applications for persons with severe mental illness that may prevent them from effectively accepting responsibility or demonstrating insight into the alleged offense?
Yeah, that can be really tricky. I think, it's possible to not have them necessarily claim innocence, but instead focus the application on their mental health issues. You can provide context if there's a tie between the mental health issues and the conviction. And you could also focus on the extreme hardship they would face if deported to that country. If there's widespread persecution of people with mental health issues in this country, the conditions in mental health facilities, availability of mental health care in those countries, and what their life would be like if they're don't have access to medication or treatment.
Thank you so much, Anoop. We have a lot of questions that we don't have time to get to towards the end, and the remainder we will definitely follow with the email. And I will move forward to a personal story of my amazing Cambodian brother, Phal, sharing his pardon process. Phal, take it away.
Cool. Hey, hi everyone. I'm about to turn the webcam on since I don't have many slides with this one. So just to kind of go over a few things. Give me 1 second. Can y'all see me? All right. So I just want to give a quick kind of breakdown just on my personal history of how I got into the situation that I got myself into, and then ultimately how we were able to pull myself out of it. So I want to start off by saying, first of all, I am Cambodian. I'm born in Thailand, just like many folks from that part of the world that came into the U.S. So when I came here, you know, like most other Southeast Asian families, we came here, didn't resettle very well. People went through a lot of difficult things. You know, my parents ended up splitting up when I was young. When I was about 2 years old, they had split up. My mom left, and so I've never gotten to know my mom. So I basically grew up with just my dad. But eventually, when I was 16, my dad had passed away, and I basically wound up in the streets for just lack of resources. You know, just there was really nothing in the community for me. The only thing that was around us were men with badges, with guns and handcuffs, and that was about it. And so I got caught up in that cycle. Ended up being tried as an adult when I was 17. Went to the state prison system for 23 years and 8 months was the prison term. But in any event, because of work that happened out here in the community on the ground, some legislation went through that gave me a chance at the parole board. And when I appeared for the parole board, I got found suitable. Unfortunately, when it was time for my release, it was a transfer to ICE. And the contractors came in and picked me up and took me out. And that was a journey in and of itself. But in any case, I got detained, ended up taking a deportation order pretty much within a couple of months. Got released on order supervision, roughly 6 months after I took the order. So I was detained for about 9 months, and then I was out for roughly 4 months. And then ICE sent me a letter to report. So I went back in, took my luggage and stuff. I was basically ready to go. But when I went, after I got detained, some folks came to visit me and stuff. They're like, "Hey, if you know how to do anything, just try to do it. We'll support you 100% of the way." So eventually I filed. I went through this legal process with the court system. It's a whole nother different matter. Not really much for this webinar here, but kind of a unique way I kind of tackled it. And basically I was able to get my case reopened. And with my case reopened, I was able to ask for a bond hearing and got the bond hearing and got essentially community paid for my bond. I got out. And so when I came out here, the only thing I knew to do was to get a pardon. There was like no other form of relief. I sued the government. I did all kinds of stuff. And mind you, I'm doing this all by myself, right? Because there is no guaranteed representation in the immigration system to begin with. But anyways, with that, I got involved with organizing with immigrant families, etc. out here. And from there, I got involved with the Youth Justice Coalition, who I currently organize with now. And through there, I was able to build a really strong network. And I was able to get the governor's ear and to sign me off on a pardon. But part of that, for me, the fortune with me was because of my work. UCLA Criminal Defense Clinic had actually came across my situation, and they decided to represent me on getting a pardon. But from there, we started to really build a network, and a network per se to reach out to legislative staff, to politicians, etc. And so I was able to get support not only from people from the community, from organizations, but also from legislators in city council, all the way up to Congress at every level, essentially. And so that was kind of the build up to it. And so that was the political push behind it to help me get the pardon, because I already had an application pending, but they basically said because I had not been out 10 years yet, good luck. And so we just went a different route. We pushed really hard. And so there were a bulk of letters, there were a bulk of pictures I put in. The application was about 500 pages roughly, but it had letters from legal experts, talked about the law, if I was, tried now, what would the situation be? I wouldn't be facing deportation, etc. On country conditions. It was very expansive, covered a lot of ground. But when we submitted it, we also submitted it with a video. And so what I mean by video is that Silicon Valley Debug came down to LA and they did a social bio video on me, interviewed a bunch of people, put in a lot of different things. A lot of people didn't even make it because there were so many people coming out to speak for me. But essentially, we made a 24-minute video. We submitted that to the governor. We submitted it as a supplement. We sent it in through a hard drive, through thumb drives, but we also sent it through links to their staffers, etc. And we were able to use whatever connections I had to be able to get it in and get it further into the office to really make it heard. And along the way, we started filing supplements. And what I mean by supplements, we were getting more letters from legislators. We were getting more letters from the community, more personal letters, etc. And that was how we kept it going. We kept the traction going. We kept my name on the table, kept the name on the list. And the folks at UCLA were constantly in touch with folks in the governor's office. And so what Anoop was talking about, making this very compelling application, we put everything, we laid everything out. We had documents for my C file, we had my A file, we had, pro board transcripts, etc. We had everything that was necessary, because that's what they based it on, because they don't really get to know anything besides you through there. And the thing is, you really have to motivate these people to make a decision, not logically, but oftentimes with their heart, right? And so we have to find a really compelling way to get them to do those things and to make things move. So right after I had filed, about 2 or 3 weeks after I had filed, I got a call from the pro board. They said they were investigating it. They said that the governor had asked for it to be investigated. There were some questions that they needed to get answers to. And then it just went from there, in just a matter of about, I want to say, 6 months, I ended up getting it granted. And just recently, we also got somebody else granted that was, last minute filing, but he was, granted pretty soon, and he was on active parole. And so just to say that these things are possible, it's not impossible. It's just a matter of how we approach it and how we do it. And it's a matter of community support coming behind it. And it's a matter of reaching out and touching networks that everybody can access, and finding a way to get to basically the grass tops within the governor's office to make it happen. For sake of time, I just want to open up the last couple of minutes or so just for Q&A.
Thank you so much, Paul. Quite the compelling story that you have. So you have any questions for Paul? I'm going to go to the chat box and see if there's questions. Okay, questions in terms for Paul. Paul, how do you keep your faith?
How do I keep my faith? Part of it is my own belief in God and Christ, I guess we could say. That's my personal faith. But also my faith is that I know that the system is changing. I am not a reform person per se. I'm more of an abolitionist, just to be honest with you all. And I believe that as people keep pushing and we're heard and we're sitting at the table with people that can make those decisions and really make an impact in our lives, as long as we can touch them, we can do it, because everybody's a person in the end. And so my faith is not in the system. My faith is in the community. My faith is in the people that I work with. My faith is on the ground, here in this planet, in this lifetime. So that's where a lot of that comes from. And because a lot of my work, I work with a lot of young people, supporting young people, making policy changes with young people alongside them. I have a lot of faith in our young people as well.
Great, thanks, Paul. Then I have can you kind of clarify what does it mean? Okay, what does it mean to accomplish while incarcerated regarding commutation, pardon, clemency? What did you do in prison?
Oh, okay. So while I was inside, so some of the challenges inside is that there are certain limits, to what you can do. Obviously, you're not a free person, so there are certain limits. But for me personally, it was always trying to get better jobs, getting clerical jobs, getting jobs where you interact with a lot of different staffers. And I mean by staffers, I mean some cops, but a lot of free staff like teachers and educators, just people that work out and about in the prison, because not everybody in the prison is somebody in a green suit or in a Class A uniform, right? There are free people that work there. And so getting jobs to support those kind of things, but also being involved with a lot of self-help groups, groups to just gain insight or to share time with other folks to have a better understanding of who you are as people, who we are as people, right? And so doing a lot of those things, self-education. I spent a lot of time learning law, to be honest. And so that really helped me a lot, to be honest. If it wasn't for that, I don't think I would have got my case reopened on my own, through the challenges that they put me through, sending me out to Louisiana and all kinds of stuff, having to navigate a system that's, they say it's the second most complex system. But essentially inside, staying out of trouble, as challenging as that is, it's doable. But unfortunately, it's not something that you can always do just because you raise your hand to do it. It really takes a lot of will, takes a lot of commitment to do those things. But anything that's seen as self-improvement, anything that's seen as self-help, those things are always beneficial. And doing things where you can get noted for, you can get chronos, you can get laudatories, you can get memos written, etc. Those are the things that matter, because then they can get documented in your C file. And so I want to leave that on this. If it's not in your C file, they say it didn't happen in there. You know, that's their standard say. So just to be mindful about that piece.
Thank you so much, Phal. Great tips. So it's 11:43. We have about 15, 20 more minutes, and we'll thank you so much, Phal, once again, and we'll proceed to our last segment with the AB 2845 Pardons and Commutation Reform Act, and I would like to pass it over to Angela Chan, my great supervisor. Hi, Angela.
Hi, everyone. Hi, Nia. Thanks for organizing this. So I'm going to be talking about AB 2845. This is the Pardon and Commutation Reform Act that was signed into law by Governor Brown last fall in September 2018, and that went into effect just this year in January 2019. What this act does, what this new law does, is it increases the transparency and accessibility of the pardon and commutation process. And I'll go into detail to explain the specific provisions of this law. Also want to recognize that Assemblymember Rob Bonta was the author of this bill, and we're really appreciative that he helped us to move this reform. Next slide. So AB 2845 does a couple things. It adds some timelines and provides some transparency. So specifically, it requires the Board of Parole Hearing, BPH, to consider expediting the review of urgent pardon and commutation applications. So this applies to both pardons and commutations. An example of urgency is if an individual is facing deportation or if they have a severe illness, and so they, for example, need a commutation, or they are trying to restore parental rights. I'm sure there are other urgent reasons, but these are probably the most common ones. Just to note that BPH doesn't have to expedite the application. It requires they consider expediting. It also doesn't have a timeline for what that means, expediting. You know, if it's 3 months, 4 months, it just says they have to consider expediting it. Another piece of AB 2845 is it requires the Board of Parole Hearing to notify applicants when they receive a pardon or a commutation application, and also they have to notify applicants when they issue their recommendation to the governor's office. This is a significant change. Our understanding from people who apply for pardons and commutation applications is that it often feels like a black box when you apply, because you submit your application and you hear nothing back about even if they receive the application. So receiving these 2 points of notice when BPH receives the application and also when they issue the recommendation will provide a little bit of a signal for where your application currently is. And again, this applies both to pardons and commutation applications. Next slide. AB 2845 also makes some changes with respect to certificate of rehabilitation. That's what Anoop talked about earlier, a certificate you can obtain from a superior court to show that you've rehabilitated, and that often helps with obtaining a pardon, although it's not guaranteed. So what AB 2845 does is it says that you can apply for a certificate of rehabilitation in two places. You can choose to apply in the county where you reside, or you can choose to apply where the conviction occurred. Prior to AB 2845, you could only apply where you reside. And this allows you also to choose to apply where the conviction occurred. You have to choose one of those places. You can't do both. But this helps if you live in a county that has a very conservative set of judges, and actually where the conviction occurred had judges that were more open-minded to granting these certificates of rehabilitation. Another thing that AB 2845 does is that it requires that county court websites have the certificate of rehabilitation application online. Our understanding is that prior to AB 2845, sometimes you'd have to go down to the courthouse to actually get the application, which can be very inconvenient. So now courts are required to actually post the applications online. You might have to print them out and fill them out versus submitting them online, because I know not, actually probably a lot of courts do not allow submission online, but at least you can get the application from online. AB 2845 also clarifies that individuals can apply for a commutation or a pardon or a certificate of rehabilitation, regardless of their immigration status. We heard of a few cases where there was some confusion and there was some opposition, for example, by district attorneys that said that people can't apply because of immigration status. That's definitely not true, and AB 2845 clarifies that you can apply regardless of status. Next slide. Lastly, AB 2845 also expands employment protections under this law that was passed a couple years ago called Ban the Box. It expands that Ban the Box protection to people who have a pardon or who received a certificate of rehabilitation. What it does is that it ensures that when employers conduct a background check in connection with an individual applying for a job, the employer can't consider convictions that have been pardoned or that have received a certificate of rehabilitation. Next slide, please. And just a shout out to all the organizations that were involved in passing AB 2845. It was really a community effort involving all the organizations listed here. We continue to work together to improve the pardon and commutation process. And actually recently had a meeting with the governor's staff where we provided additional recommendations for both implementing AB 2845 and also building on it by adopting new additional reforms. And we did, and we can send this out via our after this webinar, we sent a transition memo to Governor Newsom with these recommendations that we can share with you. And that concludes the AB 2845 section. We'll go into the Q&A session. And this is the overall Q&A for the whole presentation and for the AB 2845 piece. I'll hand this to Mia.
Thank you so much, Angela. Okay, let me go to the question box. Okay. Wow, lots of questions. Okay. Okay, what is this new? Okay, just if you can clarify, what is the new 2845 law and what's the slightly difference between the governor's pardon?
Yeah, so AB 2845, I just explained, it's not its own avenue for obtaining any relief. What it does is it improves the transparency and accessibility of the existing pardon and commutation process. So as I explained, it adds some timelines, it adds some notification requirements, it makes the certificate of rehabilitation process a little more accessible. So that's what AB 2845 does. We are working on a one-pager that would also explain AB 2845. As soon as we have that available, we'll also send that to everyone who registered for this webinar.
Thank you, Angela. And I have a question here. Perhaps this could go to Anoop. Immigration interview questions. If an inmate has a pending release on parole for work milestone credit, how can we confirm if ICE plans to interview and request a hold on immigrant inmates prior to release from CDCR?
Angela can share more about what CDCR is required to provide to people who are going to be interviewed by ICE. But generally, as someone approaches their parole date, they will receive a notice that ICE intends to interview them. They can choose to decline the interview, but they should be receiving a
Yeah, and under a law called SB 54, the California Values Act, it does provide some protections for immigrants in state prison. And so it, for example, does not allow the state prison to treat someone differently because they have an immigration hold. So it doesn't allow them to not get access to educational programs or rehabilitation programs based on the immigration status. It also prevents CDCR from factoring in their immigration status and determining classification levels. So those are some protections from SB 54. It also requires that individuals that ICE wants to interview in state prison custody, that they be given a written consent form that explains that they have a right to say no to the interview with ICE. So those are all protections under SB 54.
Thank you, Angela. And I have a question. How can I help my brother who's currently incarcerated with a pardon or commutation? I want to spearhead this for them, and I have spent the last 2 years getting a foothold in the racial justice community, non-immigrants.
I think that depends a little bit on if they're facing immigration consequences, whether you're going to be seeking a pardon or a commutation. But a good starting place would be to look at ALC's pardon guide, as I mentioned, available at bit.ly/pardon guide, capital P and capital G. The California Coalition for Women Prisoners also has a guide out on applying for a commutation.
Thank you, Anoop. And here's the question: Are there any? Are there any? Wow. Do you know of any nonprofit orgs that assist with 290 registrants applying for COR or restoring rights in general?
I think depending on where you're residing, there are a number of clean slate organizations that do assist with this. I think, Rose, I don't know if you have any other referrals, but I think it largely depends which county you're residing in.
Thank you, Anoop. And this is a question regarding, I know commutation, but just want to clarify that the person submitted a year ago and have not heard anything. Should we reply under the new AB 2845 guidelines?
Angela, I can answer that. We recently asked the governor's office this question. We've heard this question from a lot of people that now with Governor Newsom in office, what do people do who applied for a pardon or commutation under Governor Brown, but did not hear an answer from Governor Brown prior to him leaving office in January? Governor Newsom's staff told us that people should not currently reapply if they have a pending application under Governor Brown where they did not receive an answer. That Governor Newsom's office is currently working on posting their pardon and commutations applications and guidelines on Governor Newsom's website. Governor Brown's website got taken down since he's no longer in office. So they're currently working on Governor Newsom's website for pardons and commutations, and they will provide guidelines about what to do for people who have applications that were pending under Governor Brown. For now, they said to not resubmit because I think it will make it more confusing if people do not follow the new guidelines that they're going to issue.
Thank you, Angela. This question is, do you have any recommendations in terms of styling a pardon application and showing an urgent need for the pardon for an immigrant who is not currently facing deportation proceedings, but does have an order of removal and is living under an order of supervision?
So I think you can take a look at their pardon guide again about how to style some of the responses. In terms of urgency, it depends on which country, but there's been widespread pressure from the Trump administration on dozens of countries to start accepting people for deportation. So I would try and take a look at news articles or statements from Department of Homeland Security to try and determine what evidence is out there that that country may start accepting people for deportation. You can also reach out to Asian Law Caucus and other orgs to see what information they might have for your specific country.
Thank you, Anoop. And we have time for one more question. If someone pardon application is denied, how long should they wait to reapply?
In our experience, pardon applications don't actually get.
Go for it, Anoop.
So I was saying, in our experience, you don't actually get a denial on a pardon application. You just get silence back. This may change in the future, but for the moment, applications are just remain pending indefinitely.
Thank you so much, Anoop and Angela. We have a lot of questions that we don't have time for, and we'll definitely follow up in the email. We'll be happy to do so. And we do have resources available and online resources that we recommend in terms of applying for a California pardon. This is our September 2018 Asian Law Caucus Pardon Guide and the Restoration of Rights Project, which covers topics on California restoration of rights and pardon expungement and suing. The ALC Pardon Guide also has an example of a template support letter that you can use as an example, to send to people who you want to write a or letter for you to the governor on your behalf. And that's www.advancingjusticealc.org and ccresourcecenter.org for the registration of rights. And then lastly, we have our presenter's contact information. And Paul did mention to me that if I can blast his email, if you have any questions and comments in regard to what he shared, definitely email Paul Sock, PHAL.sock@youthforjustice.org. And these are our other information, our email that you can directly contact us. Again, regarding anything we have touched on today's webinar and any questions, including questions in the chat box we're not able to answer. If you are an attorney who did include in the registration information your state bar license number and state in which you are licensed in, you should receive confirmation for 1 hour of MCL credit by the end of this week. However, if you did send us the required info that we asked and you did not receive credit for it, please email me and I will follow up to make sure you get credit for this webinar. Also, one last thing before we end, if you are interested in reviewing the recording of this webinar, its entirety, please email me directly and I would be happy to share the webinar recording with you. It's been great. Thank you so much, everyone, for spending your Monday morning or afternoon with us. We hope you got a lot of valuable information and definitely best of luck in applying for your pardon or helping others in applying. Have a wonderful rest of the day and take care, everyone. Thank you for joining our How to Apply for a Pardon webinar. Thank you.